Can I get started? Okay, this session is on horizontal agreements in the context of innovation and sustainability. And thank you, Anna, for the introduction. Nicola, for the introduction. As Nicola said, my main area of expertise is digital competition law, the interactions between competition law and data protection law, and other areas of law in particular. But over the past couple of years, I've also researched and written quite a bit on green competition law and the similarities to digital competition law. So what can we learn from the discussion on digital competition law, on the inclusion of non-economic benefits such as data protection, privacy? What can we learn from that discussion when we now discuss more sustainable competition law, and how, in fact, to somehow, and this is my new area of research, how to kind of combine these two streams, so digital and green competition law, to make it more aligned with the so-called twin transition to a more sustainable, more digital economy. Let's get started. And as Nicola said, please go ahead and ask questions throughout the lecture, but towards the end, we'll also have around 10-15 minutes for questions. So the structure of the lecture is quite simple. So first, I'll start with a brief introduction, and then we'll focus on two main areas, so horizontal agreements and innovation, horizontal agreements and sustainability, and then I'll provide a few concluding remarks. So horizontal cooperation is obviously an essential way of doing business. There can be various forms of horizontal cooperation. So we may have R&D agreements, sustainability agreements, and these are the two types of agreements that we're going to discuss today. But there can be also other types of horizontal agreements, so production, commercialization, information exchange, joint purchasing, etc. And this graph is taken from the 2023 European Commission's guidelines on horizontal cooperation. So these forms of horizontal cooperation are covered in the guidelines. But as I mentioned, today we'll focus on R&D and sustainability agreements. There can obviously be various reasons why firms want to embark on horizontal cooperation. So innovation, efficiency gain, sustainability, economies of scale, etc. Now, even though horizontal cooperation can obviously bring various wonderful benefits, horizontal agreements are also the most problematic from the perspective of competition law, as you all know. So as regards competition law's applicability to horizontal agreements in the area of innovation, R&D, and sustainability, in June 2023, so last year, the European Commission adopted a new R&D horizontal block exemption regulation and new horizontal guidelines. And these two documents will be the focus of this session. In the context of the adoption of these documents, publication of these documents, Executive Vice President of the Commission, Margrethe Vestager, who is responsible for the competition portfolio, said the revised guidelines, rules on horizontal agreements, provide clear guidance to help businesses assess the compatibility of their cooperation agreements with our competition rules, including joint sustainability initiatives. And this up-to-date guidance is a key tool to push forward the green and digital transitions, so the twin transition that the EU is interested in. So here, sustainability aspects and digitalization/innovation figure quite prominently. Now, what are the steps that had led to the adoption of these two documents? So in December 2019, the European Commission presented the European Green Deal. So it is a comprehensive strategy for a more sustainable Europe. Why is it important here? So the new guidelines included a new sustainability chapter, so a guidance on how to self-assess cooperation agreements that pursue sustainability green objectives. And the inclusion of this chapter is, in fact, a reflection of a kind of a greener orientation of the EU. And in fact, the acknowledgement that public authorities, including competition authorities, will need to take their part in the achievement of sustainability objectives, of green objectives. Also, the preamble to the R&D block exemption regulation stresses that competition between undertakings on R&D can contribute to achieving the objective of the European Green Deal. So the Commission sees a clear link between horizontal cooperation and the green objectives. Then in May 2021, the Commission published a staff working document that presented the results of the evaluation of the old block exemption regulation and old guidelines dating back to 1211, 1210. And here the evaluation showed that indeed, the rules need to be adapted to the social, to the market reality, including to the green aspirations of the EU. Then in June 2021, the Commission launched an impact assessment. In March 2022, the Commission proposed new R&D block exemption regulation and accompanying horizontal guidelines. As regards the block exemption regulation, R&D block exemption regulation, it included a new provision that envisaged an exemption where no relevant market has yet emerged. So it said, it's a so-called 3+1 rule. And it said, if companies that conclude an agreement compete in innovation, there has to be 3 or more additional competing and comparable R&D efforts in the market for this block exemption to apply. And we'll come back to this rule. Then the guidelines contained a new section on sustainability agreements. Then the European Commission conducted a public consultation that included stakeholder workshop, expert opinions, discussions with interested parties, etc. Then the Commission actually decided to put the new rules on hold, so decided to delay the publication of the text by 6 months to allow for the digestion of this very extensive feedback that it received. And it particularly received a lot of feedback on sustainability cooperation and how to include it in the horizontal cooperation guidelines. And the revised guidelines were in fact extended from, I think, around 60 pages to around 160 pages. So a lot of updates were made. Then in July 2023, the European Commission published the final versions of the R&D block exemption regulation and horizontal guidelines. Interestingly, the R&D block exemption regulation no longer contained the so-called 3+1 rule that we'll come back to later on. When it comes to, and actually the updates to the R&D block exemption regulation were way less extensive than expected. So there were just few additional clarifications introduced. So what is clarifications on market shares, for example, then the regulation was slightly restructured, but importantly, this 3+1 rule was not there anymore. As regards the guidelines, the chapter on sustainability agreements remained. So let's get to the first kind of main topics, so horizontal agreements and innovation. So now, R&D cooperations are obviously extremely common in many industries. So parties may want to combine the areas of expertise, for example, in highly specialized areas such as life sciences, tech. R&D agreements can also vary in form and scope. So for example, we might have an agreement where one party finances R&D carried by another one, or we might have an agreement where they jointly carry out R&D. They may also differ in scope. So we may have agreements that cover joint improvement of existing products and technologies, or we may have agreements that aim at developing a completely new product or technology. That create an entirely new demand. So obviously, horizontal agreements can be entered into by different types of actors, so large undertakings, SMEs, startups, research institutes, and any combination of those. Now, R&D cooperation often have pro-competitive effects, and particularly when they bring together undertakings with complementary skills, with complementary assets that enables them the development of new improved products or technologies more quickly, for example, than would otherwise be the case. However, as we all know, R&D agreements can also restrict competition in different ways. they can reduce or slow down, in fact, innovation. They may lead to, in fact, a reduction of competition between the parties, for example, outside the scope of the cooperation agreement, or they may lead to anti-competitive foreclosure of third parties, for example, where one of the parties to the agreement or both have quite a lot of market power. So what is an R&D block exemption regulation, and what does it do? So the aim of the R&D block exemption regulation is to facilitate R&D while effectively protecting competition, of course. What does it do? It exempts R&D agreements that meet certain criteria from the prohibition of Article 1011. So they create the so-called safe harbor for those agreements. The exemption provided by the block exemption regulation is based on the presumption that the agreements generally fulfill the four conditions, cumulative criteria that we have in Article 1013. And what are those? So the agreement has to generate a benefit. This benefit has to be passed on to consumers. The restriction of competition has to be indispensable for the claimed benefit, and not all competition has to be eliminated. So where an R&D agreement does not fulfill the conditions under the R&D block exemption regulation, it is necessary to conduct an individual assessment of such agreements under Article 1013. But how does the block exemption regulation define R&D? So the definition is quite broad. So these are all activities aimed, for example, at acquiring know-how, at theoretical analysis, at systematic studies or experimentation, technical testing, obtaining IPRs. So many different types of activities fall under the scope of this definition. What is then an R&D agreement? It is an agreement that relates to the conditions under which these parties pursue joint R&D, paid for R&D, or joint exploitation of R&D results. Now, what is a joint R&D? It is an R&D conducted by a joint team, a joint organization. It can also be that parties jointly entrust a third party with an R&D. What is a paid for R&D? It means that one party carries out an R&D and one party pays for it. What is exploitation then of R&D results? So exploitation has again a very wide meaning. It can be seen as a natural consequence of R&D. It can take different forms. It can be joint manufacturing of the product that results from an R&D agreement, joint marketing, joint exploitation of R&D, or joint exploitation of IPRs, sorry. Joint exploitation is covered by block exemption regulation only if specific conditions are met. So for example, if the R&D results are protected by IP or know-how. Exploitation can be a separate agreement, but it can also be part of a joint or paid for R&D agreement. So these types of R&D agreements fall under the scope of the block exemption regulation. And what are the conditions? So then what are the conditions for exemption under the R&D block exemption regulation? So first of all parties have to have access to the final results of the R&D for two purposes. So for the purpose of further R&D and for the purpose of exploitation. Now the restriction of access for the purpose of further R&D can never be restricted, but the right of access can be restricted for the purpose of exploitation. If R&D agreement is concluded with research institutes, academic bodies, or undertakings that supply R&D as a commercial service, and if in the agreement it is stipulated that the results of an R&D can only be used for further research. Now, access to the final results of R&D includes IPRs, includes know-how, and it is to be granted as soon as R&D results become available. So here there's no link to the end of the agreement, but as soon as the results are there, access has to be granted. Now it can be that parties to the agreement make unequal contributions to R&D cooperation because of differing capabilities, resources, etc. And in this case, the agreement can stipulate that one party compensates the other one for access to the final result. But in this case, compensation for access may not be unreasonably high. So access has to be affordable. Now, the application of the block exemption regulation is based on market shares. What does it mean? It means that the block exemption regulation is based on the assumption that below certain levels of market shares, the R&D agreement is not problematic. So below certain levels of market shares, positive effects of R&D agreement can be expected to outweigh negative effects of an R&D agreement. So if we have an agreement, R&D agreement between competing undertakings, and that includes actual or potential competitors, the combined market share of the parties cannot exceed 25% in order to benefit from the block exemption. If we have non-competing undertakings, then there's no market share threshold, and the block exemption can always apply. Now, when it comes to the duration of exemption, if the agreement does not envisage joint exploitation of the results, then the exemption applies for the duration of the R&D agreement. And if the R&D agreement envisages joint exploitation, then the exemption applies for the period of 7 years from the time the contract product or technology is put on the market. Now, what happens afterwards, after the 7-year period? So the exemption continues to apply as long as the combined market share of the parties does not exceed 25%. Now, R&D agreements cannot benefit from the block exemption if they include one of the so-called hardcore restrictions of competition. So Article 8 of the block exemption regulation includes the so-called blacklist. And there are 7 such hardcore restrictions of competition. We don't have the time, unfortunately, to go through all of them, but just a couple of examples. So a restriction of competition is a restriction of a party's freedom to carry out R&D in a field unconnected to the agreement, or after completion of an agreement, also in the field of agreement. So if this restriction is contained in the agreement, then that agreement cannot be exempted under the block exemption regulation. Another one is limiting output or sales. There are several exceptions here. Another one is fixing prices for contract products, or fixing prices or fixing license fees for contract technologies. So 7 such restrictions of competition that exclude or make the agreement not being able to enjoy the benefit of the block exemption regulation. Then the block exemption regulation also includes a gray list with 2 so-called excluded restrictions. What does it mean? So if those restrictions are included in the agreement as such can still benefit from the block exemption if these restrictions can be severed from the agreement, so from the rest of the agreement. And what are those excluded restrictions? So one is the obligation not to challenge IPRs of the parties, IPRs that are related to an R&D or that the results of an R&D. So in other words, parties should be able to challenge IPRs of contracting parties. For example, if they know that IPRs have been granted erroneously. Then the second excluded restriction is the obligation not to grant licenses to third parties. So in other words, parties should be allowed to give license to third parties to produce the contract product or contract technology, unless the R&D agreement envisages exploitation but by at least one of the parties to the agreement. So again, if these restrictions can be severed from the rest of the agreement will still benefit from the block exemption regulation, and these restrictions are to be evaluated individually under Article 101. So that was in a nutshell what the R&D block exemption regulation says. And I wanted to go for a second to the 3+1 rule that was there in the draft block exemption regulation and that is no longer there in the current block exemption regulation. That 3+1 rule spurred quite some controversies, discussions, and I think it's quite interesting to perhaps briefly discuss it. So Article 6 of the draft block exemption regulation laid down the rules for the application of the block exemption regulation. Paragraph 1 said, where parties are non-competing undertakings, block exemption always applies. So exactly what the current block exemption regulation says. Then paragraph 2 of Article 6 said, where parties are undertakings competing for an existing product or technology, block exemption applies if market shares are less than 25%. And this is, again, similar to what the current block exemption regulation says. Now, so these two first paragraphs point to the fact that wherever there's already an existing market that we can define, those rules that are based on market thresholds apply. Now, the draft version had also, again, paragraph 3, applicable to undertakings that are competing in innovation. So applicable to situations where no market exists yet. What does it say? It says, where 2 or more of the parties to the R&D agreement are undertakings competing in innovation, the block exemption applies if there are 3 or more competing R&D efforts in addition to and comparable with those of the parties to the R&D agreement. So the European Commission proposed that if we have an innovation agreement between undertakings competing in innovation, so no actual or potential competitors, but undertakings competing in innovation, the block exemption only applies if there are already at least 3 competing R&D efforts underway. So this would effectively mean that there must be 4 competing R&D efforts for the block exemption to apply. But what are undertakings competing in innovation and what are competing comparable R&D efforts? So undertakings competing in innovation means an undertaking competing in innovation means an undertaking that is not competing for an existing product or technology and that independently engages in or would be likely to independently engage in R&D efforts which concern, and there are 2 conditions or 2 further stipulations, which concern the R&D of the same or likely substitutable new products, technologies as the ones to be covered by an R&D agreement, or R&D pursuing substantially the same aim or objective as the ones to be covered by an R&D agreement. So imagine that we have an R&D agreement that concerns the development of a new microchip for which that would create an entirely new demand, that would create a new market. If the parties of an agreement already engage or would be likely to engage in R&D on such a microchip without the agreement, they could be considered undertakings competing in innovation, okay? So the draft rule wanted to capture such agreements to make sure that innovation efforts are not eliminated as a result of an agreement. So again, according to the 3+1 rule, if companies that compete on innovation conclude an R&D agreement, they can only benefit from the exemption if there are already 3 or more competing comparable R&D efforts out there. So what are competing R&D efforts? So a competing R&D effort means an R&D effort in which a third party engages or is likely and able to independently engage, and which concerns, again, the products that can be that are covered by an R&D agreement or are in R&D that pursues substantially the same aim or objective as the ones to be covered by an R&D agreement. Now, how to define or how to find such competing comparable R&D efforts. So if I conclude an agreement with another undertaking and we compete in innovation, how do I know, how do I figure out which ones are in fact competing R&D efforts by third parties? And here, the Commission said one has to look at a number of information, such as the stage, size, and timing of R&D efforts, third parties' access to different types of resources, the IPR, know-how, other specialized assets, their previous R&D efforts, and their capability and likelihood to exploit possible results of an R&D of an R&D agreement, of R&D efforts. Now, the Commission decided to remove this provision from the final block exemption regulation. So some saw it as a kind of a missed opportunity to innovate a current approach that is based on market shares. So the argument here is that the approach that is based only on market shares cannot really capture competitor collaboration in cases in which innovation is at stake, but no products or technology market has yet emerged. But there were also critical voices that were pointing out to practical challenges, to legal uncertainty that this rule might bring. So it is unclear, or it was unclear, according to some people, how undertakings are supposed to really establish the existence of competing R&D efforts and how they can establish their comparability to their own R&D efforts, especially if we have confidential R&D. And then, you know, there's a counter argument that goes like this, that there are different types of market surveys that companies may conduct, in-house intelligence, and also what company would invest in costly R&D without really knowing what is happening out there, what is happening on the market. So anyhow, the rule was removed, but the block exemption regulation envisages for the Commission the power to withdraw the block exemption in individual cases, and one of such cases is where the existence of the R&D agreement would substantially restrict innovation competition in a particular field. So again, the rule is not there anymore, but the Commission can have another avenue to act in case it finds that the agreement restricts innovation competition. Good. Now, so where, when the R&D agreement does not benefit from the block exemption, then it is obviously necessary to evaluate whether it still restricts, whether it restricts competition under Article 101, and if it does, whether it can still be exempted under Article 101.3. And here we have to evaluate the four cumulative criteria that we have in Article 101.3. So just let me, in order to finish this section, discuss a couple of examples that can make this discussion a little bit more tangible, perhaps. So the first case is about the joint venture to develop a new component, electronic component. So imagine that we have parties A and B that are investing heavily in the development of a new electronic component. This component will create an entirely new demand. A and B are competitors at innovation level, so they're competitors in innovation, but they're not potential or actual competitors. So prototypes are there. The parties say that they will be able to bring this component to the market within 18 months. Now, only the first component will be a blockbuster. The second will not be able to recuperate considerable R&D investments. But they also figure out that if both companies start selling the product on the market simultaneously, they can both make considerable profit. And then there's nobody else developing a substitutable component. So A and B decide to combine the R&D efforts. They create a joint venture. They decide to develop company's A's prototype, produce it and supply it to both A and B. They embark on independent commercialization, and they say that the product will be able to be in the market within 12 months, less than 12 months. So quicker than if they would be, as compared to when they would be developing the products by themselves separately. And as a result of the agreement, B will abandon its own prototype. So can this agreement be exempted under the block exemption regulation? So we know that the electronic component would create an entirely new demand. So it would not just improve or substitute the existing product. So companies A and B are competitors in innovation. So competitors at innovation level, but they are not actual or potential competitors. So the agreement would not be subject to the market share threshold that is envisaged in the block exemption regulation. And so the agreement will be exempted for the duration of the R&D, obviously as long as it fulfills other criteria listed in the block exemption regulation, which includes the non-inclusion of the absence of hardcore restrictions, conditions relating to access to R&D results, etc. So this is one example. The second example relates to a research partnership in renewable technologies. So let's imagine that we have firms A, B, C that are leading players in renewable energy technologies. They set up a research partnership. This partnership defines the R&D agenda. It sets more a common long-term vision. The agenda is to be formalized by the Memorandum of Understanding. The Memorandum of Understanding is a framework for parties' cooperation. It defines objectives, terms and conditions, governance rules, etc. But the agenda is not an agreement. It is to be implemented via a number of separate subsequent agreements covering joint and paid for R&D projects. So does the block exemption regulation apply here? So again, the Memorandum of Understanding does not relate to specific R&D projects. So it establishes more general terms. So it does not constitute an agreement. So block exemption regulation is not applicable. But what about Article 101? So all parties are active in the market of renewable technologies. But the Memorandum of Understanding, again, is a high-level framework. It does not relate to specific R&D projects. So it is not possible to determine whether the parties, in fact, are actual or potential competitors for the purpose of an agreement. So their competitive relationship would really only be possible to establish once they enter into subsequent agreements that kind of implements the Memorandum of Understanding. So there's no restriction of competition here. So that was it on the part on horizontal agreements in innovation. I suggest that we move straight away to the second part, so horizontal agreements and sustainability, and then we'll discuss questions afterwards. So I'm pretty sure that you've all heard about the discussion about relaxing competition rules, in particular rules on anti-competitive agreements, in order to allow certain forms of sustainable cooperation between undertakings. This discussion has been there since a couple of years. Some national competition authorities have also been active in this field. I know the Dutch Competition Authority in particular, but I'll also be actually curious to hear about your experience with this topic, whether this is something that you discuss on a national level, to what extent. But first, perhaps before I get to the guidelines and what's in there about the self-assessment of such sustainability agreements, let me ask you a question. The question is, so first let me read it out, and then I will ask you perhaps to raise your hands if you're for A or B. So the question is, how do you view the role of competition law in advancing sustainability objectives? Answer A, it's a little bit black and white, and I am aware that there is a gray zone, okay, in between. But what would be more kind of your feeling, your sense here, and your opinion here? So answer A, competition law can only play a very limited role, even if the rules are modified to encompass sustainability objectives. Relaxing competition law, in particular Article 101, to enable green collaborations is risky. It can lead to greenwashing. It can lead to restrictions of competition. Answer B, competition law can substantially contribute to achieving sustainability goals. Efforts to relax competition rules for the sake of enabling sustainability-related collaboration are welcome and important. So again, this is a very black and white, and I'm not even sure myself where I would stand, frankly speaking. But what would be your kind of gut feeling here or your opinion here? So who would be for option number one, so A. Okay, so quite a few. Does it mean that the rest is more kind of skeptical, or not skeptical, optimistic actually? So in the horizontal cooperation guidelines published by the Commission last year, there's a separate chapter dedicated to sustainability agreements, and this is a new addition. So in the previous horizontal cooperation guidelines, this chapter was not there. So the Commission said that also it provided this guidance through the document, but it also said that it promised to provide individual guidance through guidance letters. What are such letters? So undertakings may seek informal guidance when cases give rise to kind of unprecedented issues. They present novel unresolved questions. So the Commission highlights in the guidelines that sustainability is a core principle enshrined in the treaty. It is a priority objective for the EU. So a quite strong also wording here, and kind of a clear indication that it aims to do something with sustainability agreements. But what is a sustainability agreement? It is any horizontal cooperation that pursues a sustainability objective. So here are a couple of examples. It can be an agreement between competitors to develop jointly a production of technology that reduces energy consumption, or it can be an agreement to share infrastructure with the aim of reducing environmental impact of a production process. Just a couple of examples. What does the guideline mean by sustainable development? So it is an ability of society to consume and use the resources available today without compromising the ability of future generations to meet their own needs. It is important to stress that the guidelines are not limited to environmental sustainability, but also include socio-economic kind of objectives related to sustainability. So we talk here not only about climate change, environmental degradation, pollution, but also human rights, also ensuring living income, resilient infrastructure, etc. So the premise here is that that is in the guidelines, is that competition law ensures effective competition, so also competition on sustainability, but perhaps does not account enough for negative externalities. And of course, we have sustainability regulations that address externalities and market failures. But competition law, in view of the European Commission, can do more to address this residual negative externalities, so the remaining externalities that are not addressed by regulations, for example. So in a nutshell, that's the premise. It is important to note, and as the Commission stresses in the guidelines, agreements that restrict competition cannot escape the prohibition laid down in Article 1011 simply by referring to a sustainability objective. So there has to be a genuine initiative that underlies such an agreement. Now, in sustainability cooperation guidelines, there are two main kind of issues that are discussed. So the first one is how to assess sustainability standardization agreements under Article 101.1. And the second issue is how to assess sustainability agreements under Article 101.3. And let me start with the first one, so sustainability standardization agreements. So what are such agreements? These are agreements to specify requirements that producers, distributors, retailers must meet in relation to sustainability metrics. So for example, withdrawing or phasing out non-sustainable products, plastics, fossil fuels, harmonizing packaging materials to facilitate recycling, or agreeing on standards to improve, for example, animal welfare. So giving them more space, better conditions, etc. Now, the guidelines cover only sustainability standards developed by competitors or in which competitors participate. So, for example, quality marks or quality labels. Now, sustainability standardization agreements can obviously cause a number of competition problems. They can lead to price coordination, foreclosure of alternative standards, exclusion, discrimination against other competitors. So the guidelines explain or provide information on when such a sustainability standardization agreement can escape the prohibition laid down in Article 101.1. And it lays down conditions for the so-called soft, safe harbor for sustainability standardization agreements. What are those conditions? So if all of those conditions are met, then sustainability standardization agreement can be deemed to be compatible with Article 101.1. So the sustainability standardization agreement, there has to be a transparent procedure for developing the sustainability standard. So all interested parties must be allowed to participate. The second condition is that the agreement has to be voluntary vis-à-vis third parties. And this means that it must not impose on undertakings that do not wish to participate in the standard any obligation to comply with the standard. The third one is that such agreements have to be voluntary vis-à-vis participating undertakings. So such participating undertakings have to be able to apply higher sustainability standards. Then there can be no exchange of commercially sensitive information. Then the fifth condition, there has to be a frank access given to the outcome of the standard setting process. Frank meaning fair, reasonable, non-discriminatory. And the last condition, as a result of the sustainability standardization agreement, there can be no significant price increase or quality decrease, or the combined market share cannot exceed 20% on the market share of the market affected by the standard. So again, if at least one of those conditions is not met, then the standard is to be evaluated individually under Article 101. So a quick case study just to show this. So the case study is on the creation of a fairness label. So imagine that we have NGOs and fruit traders that set up a label for fairly traded tropical fruits. In order to use the label, the traders have to make sure that the fruits come from producers that ensure fair living wages, for example, no child labor. Fruits with this label are more expensive. Any fruit trader that fulfills these conditions is able to join the label. But these fruit traders also remain free to sell their fruits without or with different labels. The conditions for participation in the label are transparent. The methodology is available on the webpage. Now imagine this FTF label is introduced in the EU. And a large number of traders use the label. They sign an agreement to respect the label's minimum conditions. When it comes to the market share of these food traders, they have not considerable market shares, so 12% in pineapples, 20% in mangoes, and same traders operate outside the label. So this label may benefit from the so-called soft safe harbor envisaged in the guidelines. It does not restrict Article 101.1. And why? For several reasons. So parties to the agreement have quite modest market shares. There's competition also from other labels, from conventional products. Participation in the label is also voluntary, so it is not mandatory for third parties. The standardization agreement does not involve an exchange of information. The license to use the label depends only on respecting certain minimum conditions, and the agreement may, in fact, widen the choice available to consumers because it enables them to choose to identify fair trade produce. So this type of agreement would benefit from the so-called soft safe harbor. Now, besides providing the guidance on how to assess sustainability standards or compatibility of such standards with Article 101.1, the guidelines also explain how sustainability benefits can be approached under Article 101, paragraph 3. So if we have a sustainability agreement that restricts competition, can it be justified under paragraph 3 of Article 101? And here I'll go through all the four conditions that normally have to be satisfied under Article 113. And the first of these conditions is that the agreement has to produce efficiency gains, has to produce a benefit. So what are sustainability-related benefits, sustainability-related efficiency gains? So the European Commission understands such a benefit in a very broad way. So, for example, such a benefit can be the use of less polluting production, distribution technologies. It can be improved conditions of production distribution. It can be a more resilient infrastructure, resilient supply chains, shortening time of bringing sustainable products to the market. So again, a very broad definition or a broad understanding of what a sustainability related efficiency gain benefit can be. Now, of course, if companies present or argue that the agreement will result in a benefit, this benefit has to be substantiated. It has to be objective, concrete, and verifiable. So if, for example, the claimed efficiency is the reduction of water contamination, then undertakings have to explain how exactly this agreement contributes to achieving this objective and has to give an estimate of the, in a way, magnitude of this benefit. The second criterion, indispensability. So the agreement and the restrictions are obviously have to be necessary for the claim benefit, and no restrictive means must be available. So even if we have some green regulation that addresses some market failures, cooperation may still be indispensable to achieve sustainability objective. So for example, an agreement might be indispensable to achieve a higher sustainability standard than the one laid down in a regulation. An agreement might also be indispensable to reach a sustainability standard or goal in a more cost-efficient way, in a cheaper way, or in a quicker way. So again, the indispensability is the second criterion that needs to be assessed. The third criterion is that the sustainability-related benefit has to be passed on to final consumers. And I think this is the most interesting, in a way, category when it comes to sustainability agreements. And the European Commission provided here some explanation when a sustainability benefit is passed on to consumers. So it introduced three categories for passing on benefits to consumers. The first category is quite straightforward. So these are individual use value benefits. So what are those? So these are direct benefits that consumers derive from the consumption of a sustainable product. So for example, I eat a vegetable that is cultivated using organic fertilizers because it tastes better and is better for my health. Or an agreement can be about replacing plastic with durable materials. It increases products' longevity, and it is better for me as a consumer because I can longer use this product. So again, this is a direct benefit that we as consumers get from using a more sustainable product. The second category is more complicated. So these are so-called individual non-use value benefits. And these are indirect benefits that result from the fact that we as consumers appreciate our sustainable choices and their impact on others. So for example, I use a particular washing liquid because it contaminates the water less in other parts of the world, but I pay more for this liquid. So I'm affected by the agreement in a way. Or I drink a sustainably grown coffee, for example, and I'm willing to pay for it because I appreciate that coffee farmers are paid fairly. So the benefit is realized outside of the relevant market. So consumers' experience of the product is in fact not directly improved. But we as consumers are willing to pay for it, for example, to benefit society, other parts of the society, future generations, etc. Now, this type of benefit has to be obviously measured somehow or shown. And here, undertakings can, for example, measure consumers' willingness to pay by conducting consumer surveys, etc. Now, the only issue, or one of the issues here with this category, is what if consumers do not care about how their choice affects others? Really, this category only includes situations where we as consumers care about how our choices affect the society, affect other people in other parts of the world. And if they're in fact willing to pay for such an out-of-market benefit. So this is the second category of what it means to pass on the benefit to consumers. And the third one is the collective benefit that relates to the relevant market. So what are those? So those are benefits that occur irrespective of our individual appreciation. So they accrue to a wider section of society. So such benefits can be considered only if consumers that are in fact affected by the restriction and that benefit from the agreement are the same. So for example, drivers are purchasing more expensive but less polluting fuel, and those drivers are also citizens which benefit from the cleaner air. So they pay, but they also benefit from it. So again, as opposed to the second category that we've just discussed, the agreement benefits the affected consumers too. The benefit is not out of market, it does not accrue to other parts of the society, but me as a consumer kind of benefit from it as well. So this societal benefit is in a way realized in the same market where the restriction of competition takes place. Now, parties to the agreement can then rely on any of these three categories that I've just explained of this type of consumer benefit and when it is passed on to the final consumers. Now, the fourth category that needs to be satisfied, and I'll finish with that because I think we're kind of slightly running out of time, is the does the session finishes half past? Half past, okay. So the fourth and the last condition is that not all effective competition can be eliminated as a result of the agreement. And this condition can be satisfied even if the agreement covers the entire industry, as long as the parties continue to compete on some parameters of competition. So for example, parties may agree not to use a certain particular polluting technology. So the restriction of competition is here, but all competition will not be eliminated if, for example, parties still compete on the price of the final product. So if there is still some competition that remains in the market.